Hello and welcome to a special edition of the Tennessee Informer. Tonight we'll be streaming on YouTube, Facebook, and Rumble. Thank you all for joining us tonight. I'm going to talk about some important legislation working its way through the legislature. I can't cover everything, but we'll try to highlight some of the important legislation that you might not be aware of. By no means is this the only important legislation, and I will reference some other links. Now let's go ahead and get started. Before I go with the list that I had, I got some late-breaking information, or something that I overlooked earlier, and I just want to let you know about it. This is a bill that will be in the Senate committee tomorrow in the state and local government. It's by Senator Pody. It's Senate Bill 0027, and this bill is designed to limit the Tennessee governor's emergency powers. If you remember back during COVID, our governor, although he wasn't as bad as some, was still out of control and still did things that he was not authorized to do, still violated our Constitution. Our state Constitution right up front has a Bill of Rights, and it makes it clear that under no circumstances should that Bill of Rights be violated. Matter of fact, it's supposed to be off hands to the legislature anyway. They're not even supposed to have anything to do, anything that would violate the Bill of Rights that are in the beginning of our state Constitution. That's reiterated later in the Constitution under miscellaneous provisions. I think that's Article 16, Section 11, or maybe it's Article 11, Section 16, but it's there. And it talks about the Bill of Rights not allowed to be violated for any reason whatsoever. So Senator Pody has this legislation, and essentially that's what it says. You know, the governor has emergency powers, but he cannot violate what's in our state Constitution under the guise of an emergency, okay? So anything he were to declare that's in conflict with the Constitution would be unconstitutional. And so this is trying to put some control on the governor, which he definitely needs. Now, remember, not only the governor, but all the legislators take an oath to uphold both the U.S. and the state Constitution. This should be a no-brainer, but there's been pushback on it. Matter of fact, I remember several months ago, Senator Pody was getting an opinion from the AG on this legislation, and I don't have that AG's opinion available, but you can go look it up. Just ridiculous, absolutely ridiculous, the comments made in this AG's opinion. It's as if they're not reading the same Constitution. It's as if the Bill of Rights, the Declaration of Rights, as it's called in the Tennessee Constitution, doesn't even exist. And it's all about catering to the governor. So this bill is supposed to basically say, look, those limits that are in our state Constitution right up front, hey, we mean them. And governor, no matter what the situation is, yes, you have some certain level of emergency powers, but that level does not allow you to violate our state Constitution. So this is legislation that we really desperately need to get passed. This is going to the State and Local Government Committee in the Senate tomorrow, I think about 10:30 in the morning. And we have a link on our website that you can click on there, and it gives you all of the phone numbers. I can tell you who's on that committee pretty much. It's headed up by Senator Briggs. Senator Hatcher is on there, Senator Roberts, Senator Jackson, Senator Gardenhire, and let's see, there's also Senator Kyle and Yarborough. Now, they're Democrats, they're far lefties, but you know what? If it's putting some reins in on the governor, maybe they'll support the legislation. But do your best to try to get a call in tomorrow to this committee and encourage them to support Senate Bill 0027 by Senator Pody. Now to firearms. To begin with, anything firearms related in Tennessee, the go-to source is Tennessee Firearms Association. TFA is currently supporting 8 bills and tracking over 70. And a lot of those bills they're opposing. Some of those bills, too early to tell because a lot of them are in caption form. Captions don't really tell you what's going to be in the bill. It tells you what Tennessee codes are going to be affected. So they're really watching all those close. But one key bill they are supporting this year to try to get through is House Joint Resolution 0053. That's by Representative Jay Reedy. And this bill basically changed our state constitution back to the original language of our 1796 Constitution. It says it basically, right now it says the right to keep and bear arms shall not be infringed. It says, but the legislature may write laws with an order, may restrict the wearing of arms, the carrying of arms, with a view to preventing crime. So they say we have the right to keep and bear arms, and then they added a clause to that that allows the legislature to restrict us from fully exercising that. Well, what this resolution would do, if it became law, if it was, because it's a constitutional amendment, and I'll explain the process here in just a second, it would change it back to the 1796 Constitution, which then it's all it would say is you have the right to keep and bear arms in Tennessee. That's the way it originally was. That's the way it needs to be. Now, last session, that was passed in the Senate. It looked like it was going to be passed in the House, and then there was some shenanigans at the end, and it was prevented. It wasn't even allowed to be heard. Now, the way to get an amendment to the Constitution passed in Tennessee works is you have to pass it. Both House and Senate have to pass it 2 consecutive sessions, okay? And then it would be a constitutional amendment on the ballot the next time you elect a governor. So we're electing a governor in 26. Well, since it didn't get through in 24, then there's no way that it can actually be on the ballot in 26. But if we pass it this time in the House, get it passed in the Senate, and the Senate's not going to move it, the Senate sponsor is Senator Stevens. He's not going to move it unless the House version passes, okay? And then it gets passed this year, it gets passed, it could be on the ballot. The earliest it could be on the ballot will be the gubernatorial election in 2030. Would have been 2026, but some of the leadership in our House decided they really didn't want to go along with that. That's what it comes down to. So that's a bill that we definitely need to pass, and that is going to be heard in the House Civil Justice Subcommittee February 26th. That's this Wednesday, the House Civil Justice Subcommittee. So now I don't have the names and numbers of everything up here. I think I do have that one on our website. If not, the state website, tn.gov, it's a good site, guys, and you can look up all the subcommittees. You can look up the numbers for all the members of the committee, but we need your support on this one. Some other bills that the TFA is supporting: Senate Bill 441, House Bill 478, and this is carrying of a firearm into an area where firearms are not permitted. And this is by Senator Bailey and Representative Butler. A person that does not, basically if you carry it where it's not allowed, it's not going to be considered an offense if the person possesses or carries, if the area is posted and they carry it, as long as when you're asked to leave by an individual authorized to ask you to leave, then there will be no charge, okay? You can leave or you can go store your weapon in your vehicle, and that would do away with the penalty for being in there and having your weapon. Sometimes you forget. You definitely forget sometimes. So that's another one of the bills you're supporting. Another one is Senate Bill 474, House Bill 387, prohibits a healthcare provider from inquiring as to a patient's ownership of firearm ammunition. This is by Senator Bowling, Representative Butler. Prohibits a healthcare provider from inquiring as to a patient's ownership, possession of, or access to firearm ammunition or firearm accessories. And prohibits a healthcare provider from denying future treatment of a patient based upon a patient's ownership or control of a firearm ammunition, or firearm accessories. I didn't know they could do that. And it subjects the healthcare provider to disciplinary action and a fine of $1,000 if the healthcare provider makes such inquiries. And that one's not scheduled yet, but it'll be coming down the pike there in a little bit. Just keep your eyes open. I'm just going to list some of these that are being supported by the TFA. And let's see. There's another one: removes the criminal offense of possession of a weapon in a building or property that is posted. removes the requirement that the Department of Safety suspend or revoke. So this is another one having to do with buildings, and this is by Representative Warder and Senator Hensley, two very pro-Second Amendment legislators. It removes the requirement that the Department of Safety suspend or revoke a handgun carry permit for a violation on that offense by a handgun permit holder. And let's see, Senate Bill 1227, House Bill 1189, enhanced and concealed carry firearm permits. I'm sorry, I gave you the wrong ones. That's Senator Lowe and Senator Grills. Renames enhanced and concealed handgun permits as carry permits as enhanced and concealed firearm permits. So you're not limited just to handguns. Anything that's legal to carry, you can carry. That's the goal of this if you're a permit holder. Okay, slide down here just a little bit. We got a couple of more gun bills and we're going to get into some different things, but you need to start, go to the TFA website. Hey, they have a great website. You don't have to be a member to go to the website. You can look, you can see all the bills they're supporting, all the bills they're opposing. You can see who the sponsors are. You can see the committees. You can see when they're scheduled for the committees. It's a great website. Also, you can sign up and they will send you an email letting you know, hey, this bill is up this week. The only one that we're tracking for this week is House Joint Resolution 053 that I mentioned a few minutes ago by Representative Reedy for the constitutional amendment. All right, so now start contacting your legislators. Let them know that you insist that they pass truly pro-Second Amendment laws, such as the constitutional amendment to make Tennessee's Constitution consistent with the Second Amendment. Enact real constitutional carry. Remember, we don't have it. We have Tennessee Code annotated that right now makes it a crime to carry a firearm. Your permit is a defense to that, but right now it's still a crime. So how is it they can claim that we have constitutional carry if you have to have a permit in order to carry? So we want to eliminate the ban also on carrying long arms, eliminate gun-free zones. Gun-free zones are just killing zones for crazy people with guns that are going to kill somebody no matter what. And then that just leaves all of those people, all the innocent people, unarmed. Want to make a violation of the Second Amendment rights a civil rights violation under state law. That's another thing that we should support. Change the law to allow citizens to effectively defend their home and property from criminals. Did you know right now in Tennessee, if you hear somebody out there breaking into your car, you can't go out there and use deadly force to protect your vehicle. Or if you have animals, you can't protect them. Whatever. You can only use deadly force if you think your life is being threatened, okay? You can't do it to protect your property. You need to be able to protect your property. You can't even brandish the weapon right now to protect your property. And that needs to change. Stop anything that looks like a red flag law. Finally, if you conclude that Tennessee's laws do not fully satisfy the Second Amendment's shall not be infringed mandate, call the governor, call the Republican legislative leaders, and call and ask your own legislators and ask them why. Why does Tennessee continue to violate the Second Amendment? You can call Governor Bill Lee at 615-741-2001, Lieutenant Governor Randy McNally, 615-741-6806, Speaker of the House Cameron Sexton, 615-741-2343, and Senator Jack Johnson at 615-741-2495. And let's not forget the spike-haired boy there, Representative William Lamberth, 615-741-1980. All right, there's another piece of legislation that you might not be familiar with, and it is a little bit out of the ordinary in terms of understanding it. And it's House Bill 0443 by Representative Halsey, Senate Bill 0508 by Senator Wally. And it has to do with UCC, which UCC is Uniform Commercial Code. All right, and the current Tennessee Code annotated, Section 47-8-511, this bill will amend it. This is going to amend the current legislation by deleting the section and substituting. If a securities intermediary does not have sufficient interest in a particular financial asset to satisfy both its obligations to the entitlement holders, that would be you, who have security entitlements to that financial asset, and his obligation to a creditor of the securities intermediary who has a security interest in that financial asset, then the claims of entitlement holders other than the creditor have priority over the claims of the creditor. Section 5, Tennessee Code 479305 is amended by deleting the subdivisions 3 and 4. This is going to get a little bit technical here. And I'll explain this to you again once I get through this here. Local law, the commodity intermediary's jurisdiction governs perfection, the effect of perfection or non-perfection in the priority of a security interest in a commodity contract or commodity account assigned. Okay, this is assigned to the Banking and Consumer Affairs Subcommittee. This all has to do, and I know that was a lot of stuff that you're probably not familiar with. This is amending Article 8 of the Uniform Commercial Code. The Uniform Commercial Code has been adopted by all the states. It's not a federal law. It's something that all of the states have adopted, okay? Now, not all states have adopted all aspects of it, but all states have adopted certain aspects of the Uniform Commercial Code. And here's why this is important. Here's what it does. Current law on the books in Tennessee regarding Uniform Commercial Code Article 8, investment securities, fundamentally alters the common understanding of property ownership when it comes to your investments, such as stocks, bonds, mutual funds, and exchange-traded funds, ETFs. Today, when you buy a share in an ETF, you probably think you own those shares, but you don't. What you actually own is something called a securities entitlement that gives you certain rights to those ETF shares, but you do not own the shares you thought that you bought. It gets worse. Certain provisions in the Tennessee law, specifically found in the UCC Code section 8.5-11, gives the largest bank's priority to your investments if the assets are needed to pay the debts of your broker or custodian if it becomes insolvent. It's right there in black and white. So removing the two exceptions in Tennessee UCC 8.511 simply gives you, the investor, priority over your own investments in the event your broker or custodian files for bankruptcy. Now, when opponents to this bill testify, they read from section 8.503A, and it says this: to the extent necessary for a securities intermediary to satisfy all security entitlements with respect to a particular financial asset, all interest in that financial asset held by the securities intermediary are held by the securities intermediary for the entitlement holders, which would be you. They're not property of the securities intermediary and are not subject to claims of creditors or the securities intermediary. Now, in committee testimony on this issue, it was actually, this committee testimony I'm going to refer to actually happened in South Dakota in 2024 on a bill to fix UCC, because this is something a lot of states are realizing things are out of whack on. And so several different states are trying to fix this. Okay, in an attempt to fix UCC Article 8, the code section excerpted above was read into the record twice. So they're saying, no, the money will go to you. You don't have to worry about that. That's what we'll say the pro-bankers are telling everybody. However, section 8.503A continues stating, except as otherwise provided in 8-511, and this is a very important phrase that was left off of the record, okay? They told you what they wanted you to hear, but they didn't tell you the whole story. But if you own something except as otherwise provided, do you really own it? All right, this is what the section has to say, 8511. Except as otherwise provided in subsections B and C, if a securities intermediary does not have sufficient interest in a particular financial asset to satisfy both its obligations to entitlement holders, that would be you, who have security entitlements to that financial asset, and its obligation to a creditor of the securities intermediary who has a security interest in that financial asset, the claims of entitlement holders other than the creditor have priority over the claim of the creditor. B, a claim of a creditor of a securities intermediary who has a securities interest in a financial asset held by a securities intermediary has priority over claims of the securities intermediaries holders, which would be you, who have security entitlements with respect to that financial asset if the creditor has control over the financial aspect. And also C, if a clearing corporation does not have sufficient financial assets to satisfy both its obligations to entitlement holders, that's you, who have security entitlements with respect to a financial asset, and its obligation to a creditor of the clearing corporation who has a security interest in that financial asset. The claim of the creditor has priority over the claims of the entitlement holders. That's you. These exceptions in current law give certain large banks, think too big to fail, priority over your investments if those assets are needed to pay the debts of a third party. And this is done without your knowledge or consent. And I would say without your understanding. This amendment is sponsored by Representative Halsey, simply removes these exceptions from the Tennessee law and ensures that investors retain priority to their own assets. It should have always been that way, should have always been that way. The proposed language also amends the jurisdiction terms in section 8.110 and makes a conforming amendment to 9.305. I know those numbers don't mean anything to you, to provide that any legal action between the investors and their brokers will take place in Texas. Now, why Texas? Well, Texas is a better option than New York or other places that they could do this, okay? Now, opponents of this amendment will argue that the exception in 8.51 only applies to margin accounts when an investor borrows money from their broker and pledges stocks and bonds from their account as collateral. But margin accounts are not mentioned in the statute. Further, any margin account will require a separate written loan agreement between the investor and the broker, and this separate written agreement will grant the security interest to the broker regardless of what UCC Article 8 provides. That separate written loan agreement also removes margin accounts from UCC Article 8. This subsection cannot refer to margin accounts by operational law. And the second exception in 8.5 gives creditors of clearing corporations priority over investors if the clearing company fails or has a shortfall. Which banks lend money to DTCC and its subsidiaries? Yes, the ones that own DTCC, and I forget what that acronym is for, I apologize. This is the definition of too big to fail. The 1994 revision, and this whole thing, this whole steal your money thing came in a revision to the UCC in 1994 of Article 8, was cleverly drafted to the point that investors, a lot of them, are unaware of their restricted property rights in their own investments, including IRAs and 401ks. Everything seems to operate normally, as was the intent of the drafters. But in the event of a major financial crisis with insolvencies of brokers and their investment companies, the full intent of the revision will be realized. The lead drafter for the drafting committee referred to the 1994 revision as Armageddon planning for the financial services sector. Yeah, the financial services sector is not you. You're not getting paid if this happens. It's too big to fail protection. It's still sitting in Tennessee code right now. There's a lot more information on this. And guys, I can tell you, I just understand it a little bit, but I've been convinced that this is an issue. Not so much for me. I don't have a lot of investments, but there are a lot of people out there that this could hurt. And, you know, we've seen these things happen. We've seen big institutions fail. I had a guy on the show last year named David Webb, David Rogers Webb, and he writes about this. He's the author of The Great Reset. I think some of you may be familiar with that. So he's very, very knowledgeable about it. They're going to have him come and they're going to have him give testimony in the House and Senate committee. That's probably going to be the week after next. I'm not sure if the date is set on that, okay? We'll find out more about that. But pay attention to this and get in contact with that committee. Now, something that happened last year, this is not the first time the bill has been run. Last year, I think it passed the Senate or was doing well in the Senate, and its first reading in the House went pretty well. And then some of the bankers got word on this, and they basically came down in the committee and they threatened that, hey, if Tennessee passes this, then we will not loan you any more money, and we'll do everything we can to make sure nobody loans you any money, and kind of scared them off. Now, I've got to see if I can find that tape, because all the committee meetings are taped. But, you know, this is what I was told from somebody I trust who knows. And when they call bankers down and threaten committees like that, that tells you they're really scared about something. So just keep that one in mind. And that one is, I would encourage you to go back to understand this better, because I know I'm throwing a whole lot at you. But I did a show last year, roughly this time, with David Rogers Webb. If you just go Tennessee Informer, David Rogers Webb, and you can watch the show. I think it went about an hour and a half. He does a much better job explaining it. It's worth your time. You know, hey, it's your money, so you might want to look it up. All right, some other legislation. We got election integrity bills. And one of the best organization in Tennessee is TennesseeFairElections.org. And they've got House Bill 0139 and Senate Bill 0159. That's by Representative Todd Warner and by Senator Joey Hensley. It would prohibit using voting machines or voting equipment to cast, receive, or transmit an election ballot via the internet, except for military personnel and citizens abroad. And that amends current TCA. It prohibits machines from receiving, transmitting, or casting ballots using internet connections. Maintains current accommodations for military and dependents. Okay, slide down here. There is another one, House Bill 0722, Senate Bill 0823 for Representative Warner and Senator Hensley, clarifies that the county election commissioners have the duty to purge. The county election commissions have the duty to purge the permanent registration records of certain voters unless otherwise prohibited by federal law. You know, there are dead voters on the rolls in a lot of places still. Okay, not purging. And this basically repeals current code which prohibits systematic voter roll purging 90 days prior to a regular August election. And let me slide down. All right. Anyway, that's there are other election bills. I would recommend you that you go to their website and look up all the different election bills that are coming either up this week or coming sometime this session. A really good website, good information. They've got the bills listed that they support and the ones that they oppose. Now, like I said, I can't provide you everything on here in just a little short bit of time. And there's so many bills. They run 1,500, 2,000 bills every year. Nobody can keep up with all of them. There's a lot of bad ones out there. There are some good ones. There's some that's yet to be seen because they're a caption bill. You don't know yet if they're good, bad, or ugly. Tennessee Stands does a great job of tracking bills. So I encourage you to go on their website and see what they're tracking. Tennessee Eagle Forum, same thing, great resources. So there's a lot out there, and you just, you have to be proactive. Calls are important, emails are important. The committees meet on Tuesdays and Wednesdays. Monday nights, they're voting on whatever they passed out of the committee the following week. So, not much is going on. There's nothing going on in committees on Mondays. It's Tuesdays, Wednesdays. Thursdays are usually pretty short days. I don't think they actually meet in committees, and they're not there on Fridays. But just get involved. There's a lot of different sites. Now, nullification. That's a very important bill for us here in Tennessee. And we know the Senate bill, 0479 by Senator Bowling, she wants to get that through the Senate committee first before it gets to the House committees. And the House bill is House Bill 0441 by Representative Halsey. She did put it on notice this week. So it may be in the Senate as early as next week, and it'll be going to the state and local government committee in the Senate. And we have, if you look on our website, we have the link to that. You click on it, it'll show you who's on the committee. That's Senator Briggs, Hatcher, Roberts, Ed Jackson. Let's see, we've got Gardenhire. We've got Senators Kyle and Yarborough. They're far lefties, but hey, never know. Doesn't hurt to ask. We need to get this bill through the committees, okay? And we got to put pressure on these people. I think Senator Wally is on that as well. So it'll be first in the Senate, like say, could be as early as next week, could be the week after. We don't know. The schedules normally come out Thursday or Friday of every week, and then we'll know more about what's up. And of course, understand that these bills get rolled sometimes, so we'll see how that goes. Slide down just a little bit. I think I covered all the names there. Also, Senator Lowe is also on that committee. And eventually, House Bill 441, I'm assuming if the Senate bill makes it through, then House Bill 441 will eventually go to the Public Service Subcommittee, headed by Representative Rutter. You got Representative Burkhart, Edridge, McMahon, Warner, and there's one Dem on there. Can't recall the name on that one. So that's the path of the bill. And I want to say, if you saw the earlier show, we were talking about the Defend the Guard bill, and we were talking about bringing our troops home, and talking about how our federal government has ignored the Constitution for all these years when it comes to sending our military off to war without a declaration from Congress, without a declaration of war from Congress, and they do that all the time. Well, that's also on the states for allowing that. So many of the problems we have in this country are because the federal government is doing all these things they're not supposed to do. And I know some people think that, well, the Supreme Court gets to decide what's right and wrong and what's constitutional, and we just have to rely on them, and if they make a wrong ruling, we're just stuck with it till they change their mind. But that's not the way it was designed. It's absolutely not the way it was designed. If we're ever to actually make America great again, we have to make America states again. That means your states have to start stepping up. And we're going to have to demand it. And nullification process bill, that's all this is. It's a process bill. States already have the right. Now, by the way, on nullification, I want to talk about that just a little bit based on some of the things I have heard our AG say in his opinion and some of the legislators. They tell us, and this was in the AG's opinion, that nullification is unconstitutional. He said basically for two things. He said the supremacy clause in the Constitution, which is in Article 6, and because the Supreme Court makes the final decision on anything. Okay, now that's the bill of goods that they sold us, and that's the bill of goods that to a great degree we've operated under, especially in the last 100 years or so. Not saying that there haven't been earlier bad decisions we've gone by, but it's only gotten worse. The inch we gave the federal government way back is now yards and yards, miles and miles, okay? So they're doing much more than what they ever did. They're exerting much more authority than what they're given in the Constitution. But they'll tell us that. They'll say nullification is unconstitutional. Yet, our state has actually been practicing nullification at a minimum since June of 2022 with the Bruen decision, okay? Now, the Bruen decision has to do with the Second Amendment. It says if it was not a restriction in 1791, then states can't use it now as a restriction. So it doesn't match up with something that was on the books in 1791. It's unconstitutional. And they've applied it to the states. Now, obviously, I disagree with all that, but that's what they tell us. They say that the court gets to make the call and all federal law is supreme. Well, a couple things there. Even the Supreme Court has never said all federal law is supreme. Even Marbury versus Madison, if you actually read it, Judge Marshall said laws passed in pursuance of the Constitution. He makes it clear that it's not just all federal laws. So that's not even accurate by their definition. And then as far as the Constitution goes, as far as the Supreme Court goes, well, then why, if we have to do what they say, then why do we still have restrictions in the state of Tennessee on our Second Amendment? These guys pick and choose. But it tells me that they are not actually afraid of nullification. They're okay with ignoring a court precedent. It seems like if it involves more freedom for us in some way, shape, or form. Okay, but notice they'll ignore it even at the state level when it comes to the governor, because they fight against reining in the governor. There's been a lot of pushback on Senator Pody's bill in regards to reining in the emergency powers of the governor, despite what our state constitution says. And I know I'm talking about two different constitutions there, but my point is our legislators are a bunch of damn hypocrites, okay? And they say that we can't do nullification. And they'll say the Constitution, they'll say the Supreme Court, federal government supreme, but when they want to ignore it, they ignore it, just like they have in Bruen. So just thought I'd bring that up. Anyway, I want to appreciate everybody for tuning in tonight. I will have some event announcements and information about our guests next week in just a few minutes. I want to thank you all for taking the time to watch our program. Please be sure to hit the like and subscribe buttons as well as the notification bell so you never miss an episode. We appreciate your support. Check out our audio podcast on iHeartRadio, Spotify, and other platforms as well. Sign up for our weekly newsletter at our website, tninformer.com. Follow us on Facebook and Twitter. Visit tncss.weebly.com for more information on nullification. Better yet, sign up for the Substack on our website to get the latest updates. Stewart County GOP will meet this Thursday, 6:30 p.m. at the Stewart County Visitor Center to discuss reorganization scheduled for March 27th. Next week, our guest will be retired FBI agent David Baldwin as he remembers Philip Haney, who opposed the deep state and died under suspicious circumstances. We'll look at what he was trying to warn us about. That's it for now. Good night from Paris, Tennessee, that is.